Good afternoon. My name is Jane Landrum, and I am a Kansas City attorney, and my practice is civil defense work. So you're not going to hear anything specifically about workers' comp in this class. So if you want to run now, you can run, but I've been telling people that most of our case law will translate into the workers' comp world, and if it doesn't, you can give me or any of the attorneys you work with a call and see how it does translate. So Jace Fletcher, our associate in Kansas City, is also here with me. It's the two of us in the Kansas City office, and he's going to help me with, he's actually a lot more tech savvy than I am. So as we're talking about some of this social media, he's going to explain what your iPhone can and cannot do. So that'll be interesting. But let's just get started. My outline is pretty much following the outline in your book, so I'm not going to say everything word for word to you, but I just wanted to point out that social media in discovery in our civil cases is becoming quite prevalent. There are a lot of attorneys who are looking for some type of social media on both sides of the aisle. Plaintiffs' attorneys want it from the defendants to show what they were doing inside their car, and defense attorneys want it from plaintiffs to show what they have been complaining about and what difference, like if there's a mental anguish claim as a part of your lawsuit, which most plaintiffs' lawyers just automatically put that in their petition. And we are finding that with that mental anguish claim, that means that we might be able to get into not only their mental health records, but also into some of the social media places where they go to talk about their mental health. So not a lot of Missouri cases. So we're going to be talking about how courts will deal with motions to compel, Facebook issues, the challenge of applying traditional discovery rules to social media, which I don't think, quite frankly, they've caught up very well yet. Federal court's a little bit better than Missouri state courts. So we've got Missouri discovery rules generally. Anybody who does the practice in Missouri kind of knows our buzzwords, and I wanted to put all the buzzwords up for you because every discovery has to have geographic, temporal, or subject matter limitation, or else all of the judges will say it's overly broad. So you have to say time frame, you have to say, with regard to injuries, you have to say exactly what parts of the body. And then sometimes, like especially whenever there's discovery against an insurance company, you have to also say subject matter for that particular purpose. So it can't be all claims throughout all America. It has to be to your specific region. So that case is going to help you in Missouri. And then I always use this language in my motions to compel. Plaintiff's attorney is scorching the earth. I just like to use these buzz phrases. This last section is about the interrogated party, and this is going to apply in social media cases too. So if a defendant is asked for a certain part of her cell phone or any part of her Facebook, it is going to depend on what this person's knowledge is. So they're not going to be expected to automatically be an IT person. And this is the case I think we can use to say it still has to be within the knowledge of the person who's being compelled. Okay, so if you're asking the party to be an expert, then that, I think, should be, and who knows what every judge is going to do. I can't predict that for you, but it should be something that you can say is overly broad. There's only one safety statute that I have found. Feel free to ask questions, by the way. Interrupt me anytime you want to here. But I have found only one safety statute where it says in 304.820 that a person who is 21 or younger cannot text while driving. And there's all kinds of exceptions to this. They can actually be on the phone, surprisingly. They can be on a phone call And they can, right now the way the statute reads, they can even be on something like, their GPS, or if they're just even playing a game, something like that. The statute doesn't address it. Now, whether a judge is going to go beyond the statute, I do not know yet. There aren't any cases talking about this statute yet. But the way the statute reads, it has to be from person to person. So it has to be an email or a text or something that they're doing while they're driving, which actually is with another person. So I thought that was kind of interesting about this statute. And this last exception is it does not include reading, selecting, or entering a phone number into a handheld while you're driving, remember, for the purpose of making a telephone call. So that kind of surprised me that, apparently you can go ahead and be looking for a phone number as long as you're going to make a call and not a text. So it's a very narrow statute right now. Jace did my graphics for me. Missouri jury conduct, there's only one case. And as in jury trials, we have instruction called MAI 2.10. And the way that jury instruction now reads is that jurors cannot text or make phone calls or talk to anybody outside. It's the usual admonishment not to talk to anybody about the case, but they've added all of the social media to it. So this particular case, JT Xrel Taylor versus Anbari, the juror actually was saying things like, I've reported for duty. And he put this all on his Facebook account. And he did have some friends that asked him, what's the case about? And he refused to tell them. He said, we're not allowed to tell you. And at the very end, he wrote, civic duty fulfilled and justice served, now where's my cocktail? And the attorney that lost found out he was on his Facebook and tried to say that was juror misconduct. But the Court of Appeals decided that because he limited his comments to the basic fact that he was serving on a jury, he would never give any information about the jury itself, then that wasn't jury misconduct. So it's something to be aware of as you're in trials, as to kind of watch to see what the jurors are doing, and even in the hallway kind of a thing, because it's certainly possible that they could be, and as attorneys we're certainly, I think we're entitled to know if they were on it. And the way they did it in this case is they just asked the guy to provide his cell phone to the judge, and he did. And they just saw that on Facebook it was very innocuous comments, so they decided that was not misconduct. So most of the cases I found, I tried to stay in the Eighth Circuit because Missouri really does not have a lot about social media and cell phone use. But Rule 34 is talking about the same kind of things that Missouri discovery rules talk about. And so with regard to requests for production, they have a term called ESI, electronically stored information. And this is going to be anything in a computer or a phone with regard to what kind of software they were using. And so the way the federal rules talk about it is that it has to be, I'm jumping ahead, but it has to be described very, very deliberately, just like in every discovery rule, is that you have to specifically ask for the subject matter that you're looking for. So it can't just be all, Facebook from this period of time to that period of time. It has to be very specific about and relate to what the lawsuit is about. But the privacy issues do come into play. In this Holter versus Wells Fargo case, they were trying to get to the plaintiff's Facebook pages about his mental state. And what the judge said was, you are able to find on social media websites, anything that they talk about as stressors in their life. So that was actually broader than I thought it would be. That's pretty broad to say that they have to provide it. Now, one of the things that we've been dealing with is, how do you get it? You know, I mean, you say to a plaintiff's attorney, yes, you have to provide it to the other side, and what happens then is they say, oh, there isn't anything. And what the judge in Holter said was that plaintiff would not be required to provide passwords or usernames. That really is like coming into somebody's home and invading it, so the privacy issues all came up there. And they said that they were going to trust the plaintiff's counsel to review the social media content and communications and produce any relevant information. Yeah, I know. That's exactly what we said. Now, there is a case later that helps us a little bit in that, because I don't know if it's next or not. Let me see if it's next. This is just the way that, this is federal court, the way that can limit discovery, just exactly like Missouri court, if it's overly burdensome. And I really think this is going to apply to insurance companies in our discovery, because they're starting to go after the metadata from the insurance company computers. And so this particular type of case is going to help us to say, wait a minute, you know, there's got to be a less burdensome way, or that is too much of a burden and expense to go after all of that metadata. But I'll just keep going. Good. Expert testimony in federal cases. We've got cases in state court right now where a lot of plaintiffs' attorneys are saying that if a defendant was on the cell phone or texting or doing anything on her computer, looking down, then that equates to punitive damages. And so there are no Missouri cases on whether it raises to punitive damages. But the other issue is whether you can get an expert to come in and say that, and in this particular case, Haskins versus Haskins, they were trying to get an expert to come in to say that people on the who are texting while driving are more likely to be in accidents because of all the statistics that are out there right now. There's a lot of studies about it. And so the plaintiff's attorney wanted to bring his expert in to say, you know, here's a way for this expert to show the jury how dangerous it is, and then they were going after the punitives with it. Did you have a question?
Is it a Missouri case?
This is actually...
Didn't mean to put you on the spot, sorry.
I think it's a federal court case.
Okay.
Like they needed an expert to say they were more likely to be in accidents?
Well,
Or they
here's,
were sexy?
the judge actually said no. So you want to find the Haskins case in here? It's in this. Let's see what county it's in this stack. We'll figure it out. It was either in Minnesota or we'll find it out for you. But this court, it's definitely an 8th Circuit, so I tried to stay in 8th Circuit, so this is going to help a little bit. The judge, the court actually disagreed. They said, no, you don't need an expert for that very reason. The subject matter, everybody has their own opinion about whether being on a cell phone while you're driving makes it more dangerous or not. And one of the things we as defense lawyers have been talking about is, well, what's the difference if you're bending down and looking at your radio, or trying to put I don't know about you guys, I try to put a CD in my car, and you know, and that's just as distracting.
Or your children in the back seat.
Yeah.
It is Missouri, but it's federal district.
Okay. Thanks.
And so what this judge said in Haskins was that all that the jury is really deciding is whether that person failed to keep a careful lookout and whether that phone was distracting or not. So it was a negligence issue. And so they said no. Not only in this federal court, you know, using this particular expert testimony rule, this is where I'm not sure Missouri is going to do the exact same thing, but it's going to say that it was superfluous and irrelevant to bring in an expert for that issue. So I think it's worth trying, at least. So with motions to compel that we are creating, this is an Ohio case, but it's also an 8th Circuit. And so what happened in Peterson, and this is kind of a cautionary tale for both plaintiffs' lawyers and defense lawyers. In Peterson, it's actually a good case to go to look at what kinds of discovery questions you might want to ask, because the defendants asked for all the Facebook different entries, or all the different website entries about the injury and about the accident. And what the judge said was, if the defendants had procedurally done their job right and they forgot to give the judge the objections that the plaintiffs had made, all they did was give them the request instead of the responses from the plaintiff's attorney in their briefs. And so the judges didn't have in front of them what the plaintiff's attorney responded to. But there is, it might be dicta, but it's like the best we can do once more. But what happened was the plaintiff's attorney failed to tell the court all of the efforts that they made to look for the Facebook sites. So going back to before, where the judge is saying, oh, we trust the plaintiff's attorney, from the other side, we can say, in our motions to compel or in our, golden rule letters, whatever it is that we write to get the information, we can say to them, tell me about every effort that you made to find, these issues on your Facebook posts and these issues and, what websites you went to, what have you been on. So we can be specific in our requests. And then the plaintiff's attorney is bound, by this case at least, to say exactly what efforts were made. So it's not just going to be, hey, we're going to trust the other lawyer to look for everything. We're going to be able to say, be specific about what you looked for. Metadata. Electronically stored information really can be, and federal court, it's becoming quite an issue too, because ESI data from insurance companies, from law firms, from any of the larger corporations, it's quite the nightmare to go and find them. And we have found that you really do need an IT expert to go and help you, because there's going to be some things that you're never going to be able to find without the expert. But federal courts are definitely saying that the metadata is just like discovering any other documents. It's just going to be exactly like request for production of documents. So you really have to look at the issues that you've got in it. We're dealing with preserving some of this metadata. Now, I don't know what any insurance company's rules are on preserving. All we can do as attorneys is say, that at least in federal court, there is a rule that says that you are required to preserve metadata, not just the documents, but the documents inside the documents, all the drafts and things like that, when you're anticipating litigation. So from our perspective, we were talking about what kind of advice to give to insurance companies, and I would rather say to you, talk to your in-house counsel, talk to your general counsel about what needs to be preserved when you get, not just the lawsuit is filed, when you get notice from a plaintiff's lawyer that they're going to make a claim, because that is going to be the trigger when you are anticipating litigation, and you cannot destroy things at that point. You have to make some reasonable effort to preserve it. Now, the exception to that these are all the things that a court can do. They pretty much codified in the federal rules what spoliation is in the state court rules. You know, all of the different sanctions that it can be all the way up to dismissing an action against you, or default judgment from the defendant's perspective. This is the case that it was a local police department. It was actually a criminal case at first, but then the person who was convicted turned around and sued the police department because they said that the Frontenac Police Department, and this is a Missouri case, by the way, they destroyed their evidence. They had gone in and they had the police officers had those cameras on their cars and things like that. And when the plaintiff, who was the criminal defendant, came back to find it, everything was destroyed. And so they were trying to go under this federal rule to say that this was spoliation of evidence. But what this court found, Bry versus City of Frontenac, was was that this particular police department had a policy of what to do with their documents and metadata. And so if as a part of their policy, they already were destroying, like they would only keep the data from the cameras for 10 days or whatever it was. They had a specific policy that was already in place before this lawsuit. So that would translate into our civil world to say that if a company already had a policy, and it was a reasonable policy, obviously, that says when you're going to destroy it, that we could at least have an argument that it wasn't destroyed intentionally. That's going to be the test, whether whoever the defendant or I say insurance companies, but it happens also with businesses. We had a case where they said that our business destroyed a video of what happened at the gas station, where there was a crime at the gas station, and then they said that the defendant's security guard used too much force to stop the guy from, I think, stealing gas or something like that. And then they lost the videotape. And so what the question was whether that videotape was lost intentionally or not. And I think if the client has a policy of, every 5 days that videotape gets taped over, then that's not spoliation. And that's the same thing that is going to happen in the metadata world. And so I've got at the very end of the book that you've got some examples of discovery questions that might help you with the different kinds of things you're looking for. What Jace is going to help you with is he's been studying his iPhone, and he's got some interesting things that he's learned about what you can actually find in the iPhone. It surprises us. We try to say that there's not much on it anyway. I mean, all I've got is my texts or my Facebook posts or whatever. But iPhones are almost like cars these days when it comes to data. They can really say, give information to you about braking and turning, and he'll give you that information. Does anybody have any questions for me before we?
Well, I was just wondering about metadata and documents. Most, like Evans Dixon has a program that strips the metadata out of the prior documents.
Yeah.
Version. I suppose if you knew there was potentially a problem with that, you shouldn't do that.
Yeah, I think if it strips it before we send it, it doesn't strip it from our computers.
Oh, it does?
No, I don't think so. I think that's when we email.
It's just when it goes out.
So I do think then that it would still be, if we ever had that problem, it's still on our computers, and so if we were ordered
Or any
to.
company.
Right. This is just so somebody, when they get it, if they're tech savvy,
Go back and find out.
right, some lawyer might end up getting our metadata without us
It can be
intending to give it to them.
discovered for companies.
Right.
Word documents.
Right.
can be discovered.
Right. So, yeah, so it still might be discoverable, you know, the documents that we send or the emails that we
No, I
send.
didn't know what it was.
But we're not giving it to them right away, because we're not intending to give it to them right away. That doesn't mean we're deleting it completely. So, I know I went kind of fast.
Sure.
All right, as Jane mentioned, I'm going to talk a little bit about iPhones. Phones, what we carry generally every day with us. Am I being heard? Apple is getting ready to sell roughly its billionth iPhone this year. 85 million of them have been in the United States. Almost every client you talk to, especially in our civil arena, they carry some sort of phone with them, and frankly, this day and age, most likely it's a smartphone. Whether it be an Apple product, whether it be a Samsung product or another, they all generate and save the same type of data in them. How they each do it is different and proprietary. And for the most part, I'm going to talk about Apple products here today, but be aware that all of these products generate data and save it in some manner. And when I say no one knows what they do, my reference point is generally my parents, who are in their late 60s, have an iPhone and have no idea what it does, other than shows them pictures of their grandkids and makes phone calls. Location information. I found that people are not aware that your phone tracks you every minute of every day, everywhere you go. Not only does it track you, you can find out by clicking through your phone where you've been. So if any of you have an iPhone with you, feel free, go to your settings. I'm going to walk you through this real quick because your phone's potentially holding up to a year's worth of locations that it's been and checked into.
Is this going to be another one of those depressing things like the
It might be a little depressing. So if you click on settings, scroll down a little bit and you'll see a button that says privacy. Click on that. The one at the very top will say location services. Scroll down, you'll click on system services. Then scroll to the very bottom. Find a button that says frequent locations. Some of you might have it turned off. It's turned off on my phone. I've never had it turned on. A lot of you, as it comes as the default, is on. Once you click on frequent locations, you can scroll through everywhere your phone has been, when it was there, the GPS locations of where it was at, etc. I see people laughing. You're obviously finding data.
By the way, the next session is on how to make your life more exciting. If you've only been to home and work, we got to talk about that.
So as you can imagine, especially in the civil world, this is all information that we could find very useful, especially when there are claims of, if you run into claims of, I wasn't there, I was there at this time, I left at this time, etc. Yes, it may also show you if your life is very boring.
Is this only for iPhone?
Those are specific to iPhones and the location services, but as I said, every smartphone in their software somewhere does track the same data. Samsung, there's, I'm sure, a different way to get to it. And frankly, the reason we use iPhones is because more than 50% of smartphone users carry iPhones. Go ahead.
So here's a question. So I learned how to do this a couple months ago, how to turn it off. Someone was freaking out, telling me that they found their husband found it on his, and he was showing everyone to show them how to turn it off. So I turned mine off. Okay, but all the time before that, where it was on, is that data still in here? I'm assuming so. I'm
assuming so as well. And again, that would be information to ask the gentleman that gave the first presentation today, exactly what information is stored in there. Much of the information with regard to your phones and the metadata in them are not user accessible. That information happens to be information that they've allowed the user to go in and access and see. The vast majority of the information stored in that phone is not user accessible. Every application you use creates some sort of metadata. Photos, for instance, every photo you take gives a location. And when I say location, not just you're in Kansas City, you're in St. Louis, you're in Columbia. It gives GPS coordinates, latitude, longitude of where you were at when that photo was taken. Not only that, it gives you a time, a date, etc. It's not very difficult. And they're all called geotag photos. It's something you can display on Facebook if you want to, but that is the metadata that is attached to all of those photos every time you take them. That information is embedded in the phone, in the photos. Is that user accessible? No, it's not. You can search around all day to try to find it. As he explained earlier, there are programs you can use to go through and scrub some of that out, but generally that is not user accessible data.
I got a quick question. On the locations, frequent locations, if you have to find my iPhone and you put
can
this
use
on-
the find the iPhone app
We've had a burglar.
without those location services being on.
Okay, so I can turn this off and still do
The Find My iPhone app will still work,
Oh,
yes.
yeah, well, that was right off.
And put them in jail and everything.
You're supposed to turn,
So we're talking about this for purposes of litigation. As phones become more and more commonplace, there are a couple of areas we need to specifically look at. We've been talking about the phone hardware, exactly what it's able to pull, the software, what it geotags, what it holds. We're going to get into a second iMessages, wearables, and then there's also in-car computer systems, GPS navigation systems that are built in. All of these things record and download data, and generally they're saved for at least whatever amount of time a manufacturer has predetermined they're going to be saved. So with regard to the iPhone hardware, the iPhone itself has 3 accelerometers. They measure for those of you that remember 8th grade math, the X, Y, and Z axis all at the same time, hundreds of times per second. It also has a gyroscope, so when you turn your phone on its side, it knows to turn the screen. Compass and a barometer. These are all tracking all the data it brings in hundreds of times a second. Now, why is that important in litigation terms? If you think about the steps you take going down a hallway, it's counting. It knows when you've gone up a flight of stairs, it knows you've taken 18 steps that way, etc. It's also tracking the phone as it's sitting in your car. It is measuring the velocity when you get in a car wreck. So if that phone goes flying off the front seat of your car, it knows how quickly it moved, how quickly it stopped, what direction it moved. Again, all of this information is contained within the phone in the metadata. How you get to that information is a completely different question. But be aware, as James was talking about earlier, we do have plaintiffs' attorneys that are now moving toward, I want not only just the information, I want the phone. I want to take the phone to the expert and have them download everything that was on that phone. It does raise some privacy concerns, but that's where they're going. They want all the information that we have and that's accessible. As I said, so think about it when it happens in a motor vehicle accident. Now, iMessages, I think, are an interesting topic that, frankly, no court in the country that I have found has addressed yet. For any of those of you that have done civil litigation, done a car wreck case, the first thing you could ask for from any plaintiff's attorney is, I want the phone call records and I want the text logs from the carrier. iPhones send out 2 types of messages. If any of you are wondering why some of your messages are green and some of them are blue, I'm going to explain to you why. If your message goes out and it's green, that message has gone through Sprint, T-Mobile, whoever your carrier is, through their towers, through their servers, to the recipient. That text message is logged. So when I pull your text logs later, it's going to tell me exactly the time you sent it, who you sent it to, and if you dig a little deeper, even in their data logs, they'll tell you the towers it went through, etc. Blue messages are iMessages. Those are messages that go only between Apple devices. So if you are texting someone and it's either going to their iPhone, Mac computer, iPad, the messages go through Blue. Where those messages don't go are your carrier's servers. They go through the cloud, and they go through Apple's servers. And the reason I bring this up is I'll give you my example. I checked my text log this morning. I've sent 23 text messages this month. I can guarantee you I sent 23 iMessages to my wife today.
Right. That's why I was like, this month.
So you pull the text log up, hand it over to counsel, and it doesn't show a true representation of what was going on that phone when the accident occurred. Now, we haven't had any situation in any court that's come up where a judge has said, you have to provide the phone. I think we've had situations where we've now been pushed for that. We've obviously pushed back. There are large privacy concerns with turning your phone over. I'm sure none of you want to hand your phone over to opposing counsel and say, here, go through it, see what you find. So, why do we bring this all up? What we're trying to look here and just give you an idea of is where litigation is going. As Jane was talking about with the ESI information, with all the metadata information, there is a large amount of data that is being collected on every one of us virtually every moment of the day. To that end, who's wearing a Fitbit or a smartwatch or any of that? Okay, so there's a story out today, actually, out of Pennsylvania. A woman has been charged for falsifying police reports because she accused a gentleman of sexually assaulting her. The police didn't think her story exactly added up, so they subpoenaed and downloaded her Fitbit data. Her Fitbit data indicated she was actually in a different part of town, wide awake, walking around under virtually no distress when she claimed this alleged assault occurred. There's also a story out of California of a woman that actually discovered she was pregnant due to her Fitbit. Her heart rate became elevated. She started looking back at the data that was populated to her phone, took it to her doctor, and her doctor went, you're pregnant. So, if you're wearing one of these devices, just keep in mind, not only is your phone tracking all this metadata and creating all this data, every wearable device, every connected device you have is also downloading and storing data to your phone. Whether that data, again, becomes accessible, becomes discoverable, is a different issue, but please be aware that all this data is out there and being collected. If anybody has any questions, I think we've got time to answer them.
I also wanted to point out, it's in your materials, there's one more case I wanted you to be aware of. It is a Missouri State Appellate Court case called Saunders versus Basca, and it's the only one in Missouri talking about cell phone texting and cell phone usage. And in that case, the defendant actually got a directed verdict because she said that she was not distracted, and she basically said that she had the right of way. It was an intersection that wasn't controlled, and so the trial court said that she had the right of way. But it came out later then that it should not have been taken away from the jury because the defendant had provided her text logs, and these were just logs only, saying that she had texted at 7:04 and she had texted at 7:07, and the accident happened somewhere around that same time. And what the Court of Appeals said was, even though she testified that she was not texting during the accident, the phone logs, those text logs, created an inference that a jury could have found that she was. And that's as far as Missouri has gone so far. I mean, our courts are way behind, I mean, just like anything else. We learned that all day today. The courts and we are way behind what's happening in the computer world. So we're trying to keep up, and our trial judges are trying to keep up with us. You know, so far we have not had a judge make us give over our cell phone, and you know, we're hoping that there isn't a trial judge at least willing to do that. You know, so I'm always looking for the ways around it. You know, and the federal court cases are dealing with it faster than state court cases are. So that's kind of the best we can do for you right now. We're always looking for ways to defend our clients better, but unfortunately, this is a brand new world that we're in. So, yes.
What if you have a business cell phone and you have a personal cell phone? I mean, you can be compelled by your employer for the business one, right? Or no?
I think
I'm curious.
if you're compelled by your employer, you're
Well,
asking?
I mean, it's their phone, right?
If you're suing, well, a lot of employers, they'll tell you what your privacy policy is as soon as you get your phone. So I would say read your policy very carefully, you know, because some of us don't want to have, I have 2 phones for that very reason. So you only do your business on your work phone. Otherwise, depending on the policy, if there's a reason for them to suspect something, I think they are going to, it's their phone. It's not, if they're giving you the phone, it's not your phone.
But can a police
officer
officer request that?
Well, what's interesting about these cases, and we have been talking to different people, is that in criminal cases, I think they have the probable cause, perhaps, to come in and look in your phone. And so they're not going to have those same privacy issues that we have in the civil world. So I think from the civil standpoint, both workers' comp and civil cases, I think we have a much better argument to say there's no way, it's just exactly like that court said, you know, if you can't come into my home, you know, and look around my house for anything, and you can't come into my phone or my computer either. It's just exactly like that. So, you know, it needs to rise to the level of criminal activity for somebody to have probable cause to come into your home. And that's the way I like to look at it. It is that privacy element. And, you know, stay tuned, because a year from now we might have more information for you on some cases that we're working on, because those are becoming an issue in our cases. So, anybody else? I think we're getting close. It's 3:46, and at 3:50 is what we're done, and they want to make sure that we remind you to go back into the main hall, because you can get your prizes there. So if there aren't any more questions, we can be done. Thank you.
Thank you.